The morning sun began to filter through the windows of the hallway, casting long and steady shadows across the polished floors of the courthouse. It was a day like any other in the halls of justice, yet for those waiting behind the heavy wooden doors, it felt like the most significant moment of their lives. Inside the courtroom, the air was thick with the scent of old paper and the quiet hum of anticipation. This was a place where stories collided, where mistakes were scrutinized, and where the messy reality of human interaction was distilled into the clarity of the law. The bailiff called the court to order with a voice that had echoed through these walls for years. Case number 3048 was about to begin. The parties stepped forward, Mr. Ryan Fott and Mrs. Megan McCarthy on one side, and Mr. Roberto Encinas on the other. Ryan and Megan stood close together, a united front as both business partners and as husband and wife. For 7 years, they had built their dream from the ground up in Van Nuys, California. Their company was their lifeblood, a production design and set construction firm that turned imagination into physical reality. They built worlds for screens, but today they were dealing with the hard, unyielding facts of their own balance sheets. Mr. Encinas stood across from them, a man whose hands bore the calluses of 25 years of welding and fabrication. He had been hired in January of 2022 to bring his expertise to their projects. At the time, the arrangement had seemed perfect. He was promised a path into the union, and his hourly wage was set at $39.75. Every Wednesday, like clockwork, a direct deposit would land in his bank account, the modern equivalent of a steady handshake. However, the gears of the business had slipped. Megan explained to the court that the trouble began in April of that year. Their business was a complex dance between two entities, one union and one non-union. When Mr. Encinas was moved to a different job under the non-union branch, a clerical shadow fell over the payroll. A bookkeeper had entered his information incorrectly into the system. Because his hours varied from week to week and job to job, the fluctuations in his pay did not immediately raise any red flags. There were no flashing red lights or sirens to warn him that the money flowing into his account was more than he had earned. One week, he might net $1,800, and another week it might be $2,000. But then, the error manifested in a staggering jump. In one instance, a single deposit reached $4,645. It was not until the 22nd of September that the error was finally unearthed. The realization hit Megan and Ryan like a cold wave. They calculated that they had overpaid their employee by a total of $6,595.41. Initially, the conversation had been amicable. Megan apologized for the mistake and proposed a payment plan. According to her, Mr. Encinas had agreed, stating that he understood and would love to work something out. They had a good working relationship, or so they thought. But as the weeks turned into months, the promised repayments became a phantom, and the silence from Mr. Encinas grew heavy. The judge listened intently, her gaze sharp and discerning. She turned to the law of California, specifically the Labor Code Section 221. The law was a protective shield for employees, designed to prevent employers from unilaterally clawing back wages once they had been paid, without a written agreement, a formal stipulation signed by the employee. The employer was forbidden from taking back those funds. Megan admitted that while they had discussed it over email, they had never drafted a formal, signed contract. They had begun taking small deductions from his pay, approximately $296 at a time, believing they were within their rights. But the law did not favor their assumptions. The judge explained that because the pay varied so much, it was entirely plausible for an employee to miss the discrepancy, especially with direct deposits that one might only check once a month. The money one spent was difficult to return, despite the frustration of the employers. The statute was clear. Without that crucial piece of paper bearing a signature, their claim could not stand. The case was dismissed, leaving Megan and Ryan with a hard-learned lesson about the necessity of formal documentation in the world of business. As the first group exited, the courtroom shifted its focus to a different kind of dispute, one involving friendship and a sunny afternoon that had gone sideways. Case number 3050 brought Mr. Justin Cockrells and Mr. James McMurray III before the bench. They had been friends for 15 years, the kind of bond that usually survived the small frictions of life. But on May 21st, a golf cart had become the wedge between them. They had been at a house belonging to a friend named Bubba, watching a golf tournament and enjoying the afternoon. The neighborhood was the kind of place where people drove golf carts from house to house as easily as walking. James had arrived in his own cart around 2:30 in the afternoon. When the time came for him to leave to take care of his dog, he found his path blocked. Another golf cart, not his own, was sitting in the driveway, preventing him from backing out. The keys were in the ignition, a common occurrence in their social circle. Without seeking permission from the owner, James climbed into the cart and moved it out of his way. He claimed he set the brake and parked it safely before leaving to tend to his pet. He was gone for only 10 minutes. But in those 10 minutes, gravity or perhaps a nudge of the wind took hold. The cart rolled down the driveway and collided with Justin's parked 2011 BMW. The impact left a significant dent in the side of the car, a mechanical scar on a prized possession. Justin sought $1,482 for the repairs. James argued that it was not his cart and not his house, and therefore he should not be held responsible for the mechanical failure of a brake he had tried to set. But the judge was unmoved by his excuses. She shared a story from her own life, a moment at a grocery store in Florida that had stayed with her forever. She spoke of the responsibility one has when they move an object into a position where it can cause harm. She likened it to a shopping cart left in a parking lot. If a person leaves a cart where it can roll into a car, they are responsible for damage, regardless of whether the wind gave it the final push. The wind is not an intervening act of God that absolves a person of their initial negligence. The judge looked at James and told him that he should have simply asked whose cart it was instead of taking it upon himself to move someone else's property. By being the last person to touch the cart, he had inherited the responsibility for its actions. She ruled in favor of Justin, awarding him the full amount of the estimate. As the two friends left the courtroom, there was a glimmer of hope for their relationship. Justin insisted that regardless of the money, he would not let a dented car ruin a 15-year friendship. They would find a way to move past it, perhaps with a little more caution and a lot more communication in the future. The courtroom emptied, the echoes of the day's lessons lingering in the quiet air. It was a reminder that whether in business or in friendship, the rules we follow and the responsibilities we accept are the threads that hold the fabric of society together.